Get ready, guys, for dictation. Start. By this judgment, we shall dispose of civil writ petition number 25 of 2015, impugning the legality of order dated 14 July 2015 of Commissioner Rohtak Division, in terms of which revision filed by Gram Panchayat respondent has been accepted and resultantly order dated 20 November 1985 passed by Assistant Controller First Grade has been set aside. Stop. Since common question of law and facts are involved in the above said petitions, these are being disposed of by this common order. Stop. Briefly, the facts of the instant case are that the suit land in all these cases were Shamlet land even before consolidation. Stop. Name of the petitioners appeared in some places in the column of possession of Salamat land before the operation of Punjab Village Common Lands Regulation Act 1953. Stop. After the commencement of consolidation process, suit land was kept under the ownership of Gram Panchayat. Stop. Petitioners got that portion of Salamat land under their ownership which was within their share as proprietors. Stop. Petitioners had filed civil suit wherein Sarpanch of Gram Panchayat had given concurrence to their claim on Samlet land, and as a result of which consent decree was passed. Stop. However, later on Gram Panchayat contested the above said matter. The consent decree was set aside by judgment and decree. Stop. Though liberty was granted to initiate a fresh suit from that stage, but it was never revived by the petitioners. Stop. Instead of that, petitioners preferred appeal before district judge, but the same was dismissed. Stop. Thereafter, no further appeal or revision was filed against the order, and proceedings initiated from the stage of collective consent given by the then Sarpanch. Stop. After the commencement of Punjab Village Common Lands Regulation Haryana Amendment Act 1980, the petitioners filed application under Section 13 before the Assistant Controller First Grade for declaration that suit land did not vest in Gram Panchayat, and in fact that said land vested in them. Stop. Assistant Controller First Grade disposed of above said applications, adjudicating the suit land does not vest in Gram Panchayat. Stop. Feeling aggrieved, Gram Panchayat preferred appeals before collector, but these appeals were dismissed on 7 August 1986. Stop. Then Gram Panchayat filed revisions before Commissioner, who remitted the case to Assistant Controller First Grade to check as to whether the petitioners were in cultivating possession before consolidation. Stop. Against said remand order, civil writ petition number A38 of 1987 were filed in the High Court, wherein remand order passed by Commissioner was set aside and further Commissioner was directed to decide those cases afresh. Stop. Commissioner remanded all those cases to collector for examining revenue record and deciding the said cases afresh. Stop. Then another set of civil writ petitions were filed in the High Court, wherein wide order dated 14 December 2010 cases were remitted to Commissioner for deciding the same afresh. Stop. Then Commissioner dismissed the revision. Stop. Thereafter, both Gram Panchayat as well as petitioners filed civil writ petition number 263 of 2013, wherein all those cases were remitted back to the Commissioner for decision, and revision of Gram Panchayat have accepted, which led to the instant civil writ petition. Stop. Learned counsel for the petitioners at the very outset have argued. Stop. They further submitted that by virtue of provisions of Section 4 of Punjab Village Common Lands Regulation Act 1961, as petitioners had been in cultivating possession of suit land for more than 12 years before enactment of said act, without payment of rent or any other charges not exceeding in land revenue tax payable thereon. Stop. In this scenario, above said land could not vest in Gram Panchayat stop. London Council for the petitioners further took assistance of provisions of Section 2 of the Act 1961 to get exclusion of suit land from Shamlet. They, as the said land remained in individual cultivating possession of petitioners and it was never used or reserved for common purpose stop. After having gone through the pleadings as well as material placed on record, we are of the considered opinion that instant writ petitions are devoid of merit stop. Proceedings of previous civil suits and applications under Section 13 of the Act 1980 pertains to same matter directly and substantially in issue that whether suit land vests in Gram Panchayat or not. Stop. In civil suits, petitioners lost when collective decree was set aside. Its appeal was dismissed and no further appeal was preferred. Stop. Civil suit was finally dismissed by appellate court in October 1968, but the same was not challenged for almost 15 years. Stop. Furthermore, after the decision of district judge, jurisdiction of High Court was not buried by any other law. Stop. Order dated 28 October 1968 was never challenged. Stop. Thereafter, fresh suit under Section 13 of the Act 1980 was filed. Stop. Though proceedings under Section 145 Criminal Procedure Code were pending during intervening period, but those proceedings which only applied to maintain law and order by attaching a property and further with the scope to get the dispute adjudicated through civil court or any other court of competent jurisdiction. Stop. Apart from that, no application for condonation of delay was moved in all the above said applications under Section 13 of the Act. Stop. Though provisions of the Section 13 of the Act entitle a person to file suit for adjudication before Assistant Controller First Grade within a period of 2 years from the date of commencement of Act 1980, but said amendment did not revive the cause of action which had already been adjudicated or had become time barred. Stop. To this effect, reliance can also be placed on ruling Krishan Kumar versus Commissioner Hisar Division. Stop. A careful reading of the provisions contained in Section 13 of the Amendment Act would go to show that a suit for adjudication as to whether any land or immovable property is Shamlet Dehe or not and whether any land or movable property or any right, title or interest therein vests or does not vest in the panchayat can be filed within 2 years of coming into force of the Amendment Act. Stop. The provisions of Section 13 clearly and unambiguously provide only for filing of suit claiming the reliefs set out therein within a period of 2 years from the date of Amendment Act. Stop. There is no provision nor any can be read or implied in Section 13 to revive a cause of action which has already been adjudicated. Stop. Petitioners lost their claim when their collective decree was set aside. Stop. They also lost in appeal and further they did not pursue the remedy of relieving the litigation from the stage of collective admission made by the then Sarpanch. Stop. Nor they preferred appeal or revision impugning the legality of judgment and as such above said matter had attained finality and became time barred. Thus, due to enactment of provisions of Act 1980, petitioners are not entitled to pursue the matter afresh. Stop. Section 13 of the Act 1980 does not revive the cause of action which is already time barred. Stop. A bare perusal of provisions of Section 2 of the Act postulates that the land being Shamlet was in individual cultivating possession of co-sharers not being in excess of their respective shares in such Shamlet Day on or before 26 January 1950. Stop. To seek exemption on the ground of Section 2 of the Act, the petitioners are required to prove that they are proprietors in the village and the suit land was assessed to land revenue stop. Thank you guys.